Welcome to Musca Law Radio, a program dedicated to criminal defense. Musca Law is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Your host today is attorney Harley Brook, a full-time associate of Musca Law. Mr. Brook has been practicing criminal defense for 12 years and has devoted his career to representing clients on criminal law matters. Mr. Brook is a former statewide prosecutor and a former assistant state attorney. In addition, he served as magistrate, presiding over traffic matters until practicing criminal defense. While practicing criminal defense. If you or someone you know is under investigation or accused of a crime, or if you have questions related to criminal law, now is your chance to call in. To watch the show stream live, log on to muscalaw.com. That's MUSCA law.com. And click on the radio link. And now, join us live on Musca Law Radio, and here's your host, attorney Harley Brook.
Good afternoon, folks. It's a pleasure for me to be here doing this show. It gives me the opportunity to talk about something that I'm truly passionate about, and that's my job and career as a criminal defense attorney. I have the pleasure of doing something not only that I have experience in and that I enjoy, but also that I love and that I get to help other people with their issues. With our criminal defense clients, we represent folks from all ends of the spectrum, sociogeographically, and we do our very best to provide them with the best possible outcome to their cases, and I think the outcome more often than not is extremely favorable. So the purpose of this show, on the other hand, is not to talk about our firm specifically, but to help educate you all out there on issues in regards to criminal defense law. And again, I'm very excited to be here today. Not sure that I have the face for podcast or the voice for radio, but either way, I'm here, and I'm happy to take any calls or questions that you all may have for me. You can reach us directly at 1-888-565-1470. That's 1-888-565-1470. Any questions in regards to any criminal defense matters? We're going to concentrate a little bit on DUI defense more than anything else, but certainly if any callers have any questions in regards to any other types of criminal defense matters, I'd be happy to take those calls and answer those questions. One of the calls that I get with a certain frequency, quite a bit actually, is from a potential client who asks, Harley, do I need an attorney in this case, particularly in regards to a first offense DUI? The answer to that question is absolutely. Anytime you are facing a criminal law matter, anytime you've been arrested or accused of a criminal offense, you absolutely need an attorney to guide you through that process. It's extremely important and crucial that you engage the services of a qualified, experienced attorney, because frankly, the ramifications of that criminal matter are way too important to leave in the hands of an attorney that is not properly qualified or experienced. The consequences can be quite severe. In dealing specifically with DUI law, I can tell you that DUI offenses are the most heavily regulated type of criminal offense as a misdemeanor. So domestic violence being probably number two. With every DUI case, if you are convicted of a DUI offense, even as a first offense, you're facing up to 6 months in jail, facing a driver's license suspension of 6 to 12 months, 50 hours of community service, 10-day vehicle impound, a victim impact panel. There's just a number of issues that you could be facing upon a conviction. So it's important, again, that you retain the services of a qualified and competent attorney to avoid those types of sanctions. Obviously, every case is unique. Every case presents its own set of challenges or favorable type of evidence that we can attack. And so the outcome of each case obviously is going to be dictated by the facts of the case, but also just as important by the level and competency of the representation that you have in dealing with those DUIs. In 12 years of experience in handling criminal cases, both as a prosecutor in the beginning and for the last 9 years as a criminal defense attorney, I've had the opportunity to handle all types of DUIs, hundreds of thousands of DUI cases, so I've seen the spectrum. And again, I cannot emphasize enough the importance of hiring an attorney that knows what they're doing, hiring a firm that knows what they're doing, so that you can get the best available or the best possible outcome. And a DUI is a type of offense that is one that it's what we call stackable. So in other words, if you have a prior offense, the second offense, the consequences or penalties for that offense are more severe, and so on and so forth. A DUI first offense carries some mandatory sanctions. Obviously, the goal of a competent and experienced DUI attorney is going to be to either have that charge dismissed or at least reduced down to what's called a reckless driving. Because what happens is, if the DUI is able to be reduced down to a reckless driving charge, that means that those mandatory sanctions that go with the DUI kind of go out the window, or at least a lot of them do, particularly the most serious types of consequences, such as a driver's license suspension. So that's for a first offense. Now, on a second offense, if it's within 5 years, then the consequences can be even more severe in regards to some mandatory jail time of 10 days for a second offense within 5 years, as well as other more severe sanctions. If it's outside of 5 years, there's no mandatory jail time. And but the fines are usually increased. You could receive more probation and things of that nature. A third offense within 10 years can be charged as a felony, so that even becomes even more severe. The state attorney's office has the discretion to charge a DUI as a felony or not. So if you've received a DUI third offense within 10 years, the state attorney's office can actually proceed on it as a misdemeanor if they so choose. But the statutes say that a third offense within 10 years can be charged as a felony. So certainly a felony on your record is the last thing that you want. Now, I also need to qualify the third within 10 years, because not all three offenses need to occur within that 10-year time frame. There only has to be 10 years or less between the last offense and the third. So in other words, let's say, for example, that you had a DUI 18 years ago, and then you had another DUI 5 years ago, and then you pick one up now. That would actually be considered a third within 10, which would potentially lead to a felony charge. At this time, I'd like to go ahead and have Mr. John Musca join us. He's the owner and president of Musca Law, and he's going to give us some insight as well into his experience of over 15 years in handling just these types of matters. Okay. Mr. Musca?
Yes.
Okay. You're on the line there. On the line with us now is Attorney John Musca. He is the owner and president of Musca Law, and he's got over 15 years of experience in criminal defense.
Yes.
And obviously a very knowledgeable attorney to have on your side. Mr. Musca has the rare distinction of being a certified breath test operator, as well as certified in field sobriety exercises. What that means is that he has the same type of certification that a law enforcement officer has in that. And that's a distinction in as far as the field sobriety exercises and as far as the breath test instrument, which is the instrument that is used for DUI suspects to blow into to get the breath test result. That's a distinction that is very, very rare among DUI or criminal defense attorneys in general. That's something that Mr. Musca has. The reason that he has that is because, again, our goal here is to provide top-notch legal representation for our clients in dealing with particularly DUI offenses. And I'm going to go ahead and let Mr. Musca speak a little further to that extent.
Thank you. Pleasure to be here once again. Thank you, South Florida, and listeners everywhere for tuning in once again. Very important, again, to remind everybody the purpose of the show is to educate the public and to bring the public up to speed on things that they otherwise wouldn't know about the criminal law process and more specifically the focus of today's show, DUI defense. Having attorneys that focus specifically in the particular area of law is very important, and that's what we've done here with Musca Law, dedicating our practice and our careers and our lives really to representing those that are accused of DUIs. Most people do not know their rights. Most people are scared, confused, nervous, anxious. Most people are first-time offenders that have been that have been arrested for DUI. I would say on average 90% of our clients are first-time DUI offenders. So those people have never had a brush with the law. Most of them have maybe one or two traffic tickets, some no traffic tickets, no prior history whatsoever. So they come to us, and our purpose is to educate them and basically guide them through the process and obtain the absolute best result that we can.
So, again, in getting in being accused or arrested for a DUI offense, it's absolutely crucial to hire competent counsel. And we were talking a little bit about the some of the penalties associated with DUIs, and also again that's a stackable type offense. And what I mean by that is if you have prior convictions, it gets worse as you go along. And Mr. Musca, I was discussing the DUI third offense within 10 years, and how that can be a felony, charged as a felony. And on a fourth offense, regardless of the number of years, it usually is charged as a felony. So certainly, not only would it be a criminal offense on your history that could have ramifications on employment, education, getting into, schools and things of that nature. It's just something that obviously you want to avoid having those types of convictions. So
yes, that's important. The main thing is to avoid the DUI conviction, because if the DUI conviction is avoided, then the penalties and sanctions which ordinarily are triggered will not occur. I refer to those sanctions as an avalanche of penalties and sanctions. You alluded to them earlier, up to 12 months probation on a DUI first offense, up to 12 years driver's license revocation on a first offense, community service hours, victim impact panel, DUI school, ignition interlock device if warranted. The list goes on, depending on if there's any aggravating factors or circumstances associated with a DUI first. obviously, the earlier that we have a chance to intercede, the earlier that any defense lawyer has an opportunity to intercede and act on someone's behalf, the better. The DUI defense, as we discussed in our last show, is extraordinarily a time-sensitive issue. If somebody's arrested for DUI, your rights are expiring daily, so it's important to consult competent counsel as soon as possible. One further note, Mr. Brook, that I want to clarify. Earlier on, you're indicating multiple offenders. If somebody is arrested for a DUI third offense, for example, it is discretionary. In other words, it's up to the prosecutor whether the prosecutor will in fact file on a DUI third offense or not, depending on whether they have certified DUI convictions from the previous DUIs. So it is entirely possible. In fact, we've seen it happen where somebody's been arrested for a DUI third offense, even a fourth offense, and the prosecutor would file that as a misdemeanor offense. So I just wanted to qualify what you mentioned earlier, that the filing decision ultimately lies in the hands of the prosecutor, and they're the ones who make the formal filing decision.
That's exactly right, and I remember from my days as a prosecutor about 10 years ago, when I worked for the state attorney's office, that our office took a DUI to trial. It wasn't a particularly strong case from the state's perspective, but anyway, we took that case to trial. It was actually a sixth offense DUI, believe it or not, but was filed as a misdemeanor. So obviously, well beyond the fourth offense or third within 10-year threshold. It was a sixth offense, and yet the state chose to pursue it as a misdemeanor. So absolutely, they have the discretion to file on it as a felony or a misdemeanor, and that's again another area where a well-qualified and competent attorney can help reduce the charges, keeping them from becoming a felony, even if the DUI itself is such that it cannot be reduced or dismissed. There's still the possibility of having that charge reduced from a felony down to a misdemeanor, or again, like Mr. Musca said, if counsel is engaged early on in the process, competent, qualified counsel can keep the charge from ever being filed on as a felony. So in the beginning stages, and it's certainly much easier as a criminal defense attorney to have a charge reduced prior to the filing decision, prior to the prosecutor actually filing the charging document, than it is after that charging document is filed. So again, time is of the essence on these matters, on frankly all criminal defense matters, and for the same reason, and that is that would give your attorney the opportunity to get with the prosecutor who's prosecuting the case and make an argument and do everything that is possible to reduce the charges, keep them from being a felony, down to a misdemeanor, or otherwise minimizing the potential filing decision for the state, so that good outcome can start right in the beginning.
That's right, and that's important that people understand that if you're arrested for a DUI, first of all, it could happen to anybody that's just in the wrong place at the wrong time. And it happens to people from all walks of life. It doesn't matter who you are. DUI law enforcement doesn't discriminate. Anybody can be arrested, and obviously interceding early is important. Prosecutors want to know that the person's taking the charge seriously. So the sooner defense counsel can become involved, bring it to the prosecutor's attention. Hey, we have somebody that's been arrested. They are conscientious about their case. They're going to be, doing X, Y, and Z while the charges are pending. And this is an important thing to remember too. When the defense lawyers work on these cases early, anything that the defendant does while the charge is pending cannot and will not be construed as an admission of guilt. So, for example, if the person says, well, what can I do to help myself? Oftentimes we'll have a client attend the DUI school, or do some community service hours, or submit voluntarily to a substance abuse evaluation. None of that can be construed as an admission of guilt and can count against you. It can only help us later on, for example, as we approach resolution. We can pull. In other words, if we're unsuccessful achieving a dismissal of the charge on the merits of the case, which means on the strengths and weaknesses, by challenging the strengths and weaknesses of the case, then at the end, when we participate in the plea bargaining process, we could always use that as a trump card and approach the prosecutor with what the defendant has done, what our client has done while the charges are pending. And remember, prosecutors are political people, so they want something to hang their hat on and say, okay, this person did X, Y, and Z. Here's why they should be entitled to a break on the charge. Very important that some proactive things are done by the client while we're working behind the scenes to do everything that we can to get rid of the charge.
That's absolutely right, John. I can't tell you how many times I've spoken with prosecutors, and they've said, "All right, so what has your client done?" And when I'm able to come back to them and say, okay, my client has already not only enrolled but completed DUI school, is in the process of completing counseling that was required after the DUI school and all that, and has sought help if this is for a client who's had multiple offenses and the prosecutor suspects probably has some kind of an issue with alcoholism or something like that. If we can show the client has been proactive in getting treatment and things of that nature, that really helps in regards to obtaining a favorable outcome. Obviously, our goal in every single DUI case that we get, first and foremost, is to try to seek a dismissal. Are there any legal grounds to be able to do so? In other words, are there any kinds of evidence that we can use to take in front of a judge and challenge the legality of the case to ultimately get a dismissal? And I'll explain what I mean by that. For example, in order to stop a vehicle, a law enforcement officer has to have what's called probable cause for that stop. That means that in order to stop the vehicle, the law enforcement officer had to have observed something that the driver was doing unlawfully. It could be speeding. There could be something defective with the vehicle, such as a bad tail light or a bad headlight. Something wrong with the vehicle. Some kind of traffic offense that occurred. Or potentially, in a lot of these cases, a continued pattern of driving that would cause an officer to have a reasonable suspicion that the driver may have been impaired by alcohol or drugs, or maybe have some kind of a medical emergency. So, in other words, the law enforcement officer can't just stop people nilly-willy for no apparent reason. Throughout my experience of over 12 years, I've seen it happen, and I've seen officers, make up excuses that frankly were not factually or legally sufficient. Law enforcement officers are just like everyone else. They're absolutely wonderful law enforcement officers, and there are ones that are not so great. But it's our job as criminal defense attorneys to make sure that they do their jobs correctly. And so if there is a case where, and I've had them countless times, where, for example, a law enforcement officer will claim that the stop that he performed of that particular vehicle was due to, say, a bad tag light. I have one specific example within the last several months that was just this case. So anyway, the probable cause for the stop in that case was allegedly a bad tag light. Well, the beauty of most DUI defense cases, and sometimes it's not so great, but sometimes, as in this case, it's a good thing, is that almost all these stops, or most of them anyway, are recorded by video. So in this particular situation where I had a client that was stopped allegedly for a bad tag light, I had the video. I had the video of the stop itself. And what did I observe on that video? Well, I observed a tag light that was absolutely in working order. This was late at night, and it was obviously quite clear from the video that not only one but both of the tag lights that are located immediately above the license plate were in fact in working order. I pointed this out to the prosecutor right in the beginning of the case, before charges had even been filed, and or just after charges had been filed, but right in the beginning of the case when I received the video. And I pointed out to the prosecutor, listen, take a look at the video. Those tag lights were in fact operable, and therefore there was no probable cause for the stop. Prosecutor said, okay, Harley, I'll take a look at the video. Sure enough, that was verified. She came back to me and said, you know what, Harley, I agree with that. You don't have to file your motion to suppress the stop. I will go ahead and dismiss the charge. And that's exactly what happened. So that's one such situation where if there is no probable cause for the stop to begin with, then the case cannot proceed with the state. Sometimes we have to file what are called motions to suppress the stop, and go in front of the judge and challenge the legality of the stop. Because what happens is, if the stop itself isn't legal, the evidence that was obtained as a result of that unlawful stop, all of that is what's called fruit of the poisonous tree, and is therefore excluded by the judge, meaning the whole case goes away. So the state might have a situation where they have a, quote unquote slam dunk DUI. I mean, this might be a situation where the officer pulls someone over, a suspect over. There's open containers in the vehicle. The person has a strong odor of an alcoholic beverage. The boilerplate type language, as I like to use it, the red, glassy eyes and slurred speech. The kinds of things that pretty much all law enforcement officers put on their probable cause affidavits. The client can then do the field sobriety exercises, perform badly, and I'll get into the field sobriety exercises a little bit later, because that's a whole other area that we like to really attack. Then maybe the person is arrested at that point, goes to jail, blows a number well above the legal limit of a .08. Let's say the person blows a .25. The whole thing is a slam dunk for the state, right? Well, if there was no probable cause for the stop, none of that matters at all, because again, all of that evidence would be fruit of the poisonous tree. If the stop was no good, if the officer had no probable cause, no lawful authority to stop the person in the first place, then all of that evidence is out the door and the case is dismissed. So that's one of the things that a competent attorney can do for a client, and frankly, one of the first things that I look at, what was the probable cause for the stop? Sometimes there isn't a stop, it's an accident, and the officer shows later. It's still considered a stop, but not in the traditional sense where the officer turns on their lights and somebody has to be pulled over. But again, probably the first thing I look at in DUI defense cases is, what was the probable cause for the stop? Was it legal? And if there's a video that shows not only the field sobriety exercises and everything after the stop, but the stop itself, then we're going to take a look at that as well. And like I mentioned in my prior example, if the video does not jive with what the law enforcement officer is saying was the reason for the stop, then we have grounds to have the whole case potentially dismissed because of an unlawful stop. I'd also like to talk about the field sobriety exercises, and this is something that obviously Mr. Musca is very familiar with, being certified in field sobriety exercises himself. And the field sobriety exercises, for those of you that aren't necessarily familiar with the DUI, they are exercises that law enforcement officer will put a suspect through to try to determine whether or not that person is actually under the influence of usually alcohol, but could be a narcotic as well. The three most common forms of field sobriety exercise are called horizontal gaze nystagmus, And that's basically when the law enforcement officer puts essentially a lighted pin up to the suspect's eyes and moves it back and forth. He's looking for smooth pursuit of the eyes, and an uneven or unsmooth pursuit may indicate that the person may be under the influence of alcohol or some type of narcotic. The second type of field sobriety exercise that is most commonly administered is the walk and turn. That's basically where the law enforcement officer tells the person to stand one foot in front of the other and then makes them walk heel to toe for 9 steps, do a series of pivots to turn around, and then do 9 heel to steps back. And the officer's looking for numerous things, such as, for example, is the person able to keep their hands at their side during the whole time? Are they able to actually touch heel to toe, or are they walking, with their feet next to each other as opposed to back to front? Are they swaying? Are they falling off the line? Things of that nature. And then the third exercise that is most commonly used is it's called the one-legged stand. And that's where the person keeps their hands to their side, lifts up 1 foot about 6 inches off the ground, looking straight ahead, and counts out loud to 30. The officer then is looking to see whether or not the person can keep their balance, keep their hands at their side, whether they have to put their foot down, a number of things. For each one of those exercises, there's a number of clues that the officer looks for, and there's what's called a decision point, where if the person scores, usually it's two or more on each exercise of these clues, quote unquote, then the officer deems that the person did not perform well on that exercise. Now, all officers are going to tell you that these are not tests. It's not a pass or fail, but frankly, to a layman, I don't know how else to describe it. I mean, it seems to me that if you do things exactly the way that they're telling you to do, you pass it. And if you do things, if you're swaying or have more than 2 clues, then you fail. But certainly, the officer is always going to say it's not a pass-fail. It's simply a method of trying to observe whether or not a person may be impaired. Now, there are numerous issues with that, and again, most law enforcement and prosecutors will tell you that these are normal tasks that anybody that is not under the influence of alcohol or narcotics should be able to perform, and frankly, I disagree with that. First of all, the person that is performing these field sobriety exercises is under a great deal of tension and stress. Think about it. You're on the side of the road. You got an officer here performing a DUI investigation where you could potentially be put in handcuffs in a matter of minutes, and you got to nail these things or else you're going to jail. Think about the amount of pressure and stress that adds to a person and their ability to do anything at that point. And then, think about it. If these are not really normal daily activities, who walks heel to toe for 9 steps with their hands down, looking straight ahead? And, who holds their foot up? In addition to that, if the person has any kind of infirmity, in other words, let's say they have bad knees, or have natural issues regarding their balance, they're not going to perform well. And now the officer is supposed to ask, do you have any kind of a medical issue that would prevent you from performing the field sobriety exercise? But even if the answer is yes, they're still going to make you do it. Now, I talked about the 3 most common forms of field sobriety exercises. There are others. Sometimes the officer will have you recite the alphabet. Pointing finger to nose is also very common. And sometimes these are exercises that should be used on folks of a certain age, elderly type suspects. Because obviously the other field sobriety exercises are a little more onerous, a little more stressful on their bodies. So to give them another method of trying to determine whether or not the person is impaired, they may have them recite the alphabet, count backwards or do the finger to nose. But what I see very commonly is, we get elderly clients all the time, folks that are, well into their 70s, sometimes even older, that are performing these field sobriety exercises, the normal ones, the walk and turn and the one-legged stand, at the request of law enforcement. That's a big issue. That's a big issue because somebody of an advanced age or somebody who may be extremely overweight, for example, is going to have issues with that. Somebody with bad knees. And we see folks all the time that have to perform these field sobriety exercises. Well, guess what, folks? They're not going to do well. That's the bottom line. So in reviewing these cases, we look at every single field sobriety exercise, and if there are any issues that simply lend themselves to the client not performing, quote unquote, up to par or up to the standards that would be expected by a law enforcement officer, to not arrest them. So that's another aspect of DUI defense that we look at very heavily. Now, then the next step is, and I will say one more thing about the field sobriety exercises. Here's the unfortunate truth. If an officer asks you to step out of your vehicle and perform field sobriety exercises, chances are they've already determined they're going to arrest you for a DUI. And all that they're looking for at that point is padding. And that's the bottom line. That's the unfortunate truth. Within my last 12 plus years of practicing in criminal law, I can count on one hand, and in fact I can't think of more than two right now, cases where I've spoken with a client or somebody just in general that has been asked to do a field sobriety exercise or to do the field sobriety exercises and was actually let go without a DUI. It's almost unheard of. At that point, once the officer asks you to step out of the vehicle to do those field sobriety exercises, unfortunately, 9.5 or 9.9 times out of 10, it's going to lead up to an arrest.
That's exactly right. And at that point, too, going forward, it's important to invoke your Fifth Amendment right to remain silent. Because they're interested from that point forward in laying the foundation for an eventual conviction. They're not interested in helping you help yourself get off the charge. At that point, they're marshaling together evidence, and it's very important to recognize and understand that. And to proceed directly to the field sobriety exercises, what I refer to as the fox guarding the hen house. In other words, law enforcement official has done them a million times over. You're asked to do them once under a do-or-die scenario with the rest of your life literally hanging in the balance. And guess who's guarding the hen house? Guess who's watching your every move to determine if you pass or fail? The fox is. So important to invoke your right to remain silent, important to not do or say anything. At that point, the best thing to do would be to advise law enforcement respectfully and politely that you'd like to speak to your attorney before proceeding further.
And I think John makes a very good point there, that always be respectful, always be polite, regardless of the circumstances of your case. You're not doing yourself any favors by being disrespectful and uncooperative. Just because you're asserting your constitutional rights against self-incrimination does not mean that it has to be done in a rude or uncooperative manner. So it certainly will help, even if you are arrested, after the fact, if you've been polite and cooperative towards the police. I believe we have Kevin on the line who has a question. Kevin, this is Harley Brook. Go ahead with your question.
Yes, thank you, gentlemen, for taking my call. Actually, I know this is like something that's been circling around, what to do, what not to do. Out of curiosity, if I'm stopped and I guess potentially it could be an OVI DUI.
I'm sorry, what was that?
Do I blow or do I not blow? Like what's the ramifications or do if I don't? What risk am I if I don't?
Well, that's a great question, and actually one that I was going to be addressing a little bit later. But I'm glad you brought it up. It's actually the perfect time to discuss that. You know, the common theory that I hear from basically everyone that I speak with that's a layman on the subject is never blow. Never blow, just don't do it. And I don't necessarily agree with that 100% of the time. And here's why. I've had clients that literally were not drinking at all. They knew this. But the common bit of advice out there is to never blow, never blow, never blow. Well, I can tell you right now, if you know for a fact that you were not drinking, or if you had maybe one beer 2 hours ago, by all means blow. All right? Now, where I will agree with the common with the common bit of advice that I hear everywhere is, if you are anywhere close to being in doubt, then that's a situation where you may consider not giving a sample of your breath. The DUI laws are such that, and it's gotten progressively more difficult or harsher in regards to the sentence since I started practicing. When I first started practicing as a prosecutor, the enhancement level, in other words, the level at which your DUI has stricter penalties on a blow was a 0.15, was a 0.20. Was a 0.20. Now it's a 0.15. So if you blow at a 0.15 or above, you're looking at an ignition interlock device being placed on your vehicle for a minimum of 6 months on a first offense. You're looking at a higher fine of a minimum of $1,000 as opposed to $500 if the blow is under a 0.15 or if there is no blow.
So the penalties would actually escalate based upon the BAC?
Well, yes, there is a threshold, absolutely. Like I said, if you blow at a 0.15 or above, the penalties are more severe. It's almost ironic because, the state of Florida wants you to blow. However, if you blow and you blow over a 0.15, the state of Florida is going to come down on you harder. On the other hand, if you don't blow, and you would have blown a 0.15, well, then the state of Florida is going to treat you as if you had blown a 0.08 or above, but less than a 0.15. So, again, my advice to you or to anyone else is, if you're absolutely sure that you have not been drinking or that you've had a minimal amount to drink, let's say you had a beer a couple of hours prior to the stop, by all means blow. Now, if you're anywhere close to being in doubt, that's a situation where you would consider not blowing. John, I'll let you add to that.
The breathalyzer result is only one indicator of impairment. As Mr. Brook alluded to earlier, the field sobriety exercises are also a critical piece of evidence. We have had clients who have blown 000 who have been prosecuted for DUI because law enforcement is proceeding under a alternate chemical form of intoxication theory. So the breathalyzer is only one indicator of impairment, but I want to make this clear. If somebody finds himself in the unfortunate predicament of making the wrong decision and blowing over the legal limit, that merely creates a presumption of impairment. It doesn't impute guilt and result in an automatic conviction, as some would think. The prosecutors still bear the burden to prove beyond and to the exclusion of every reasonable doubt impairment. And it's important to recognize that it's not a crime to drink and drive in the state of Florida. It's a crime to drive impaired. That's the key word. Impaired driving is really what the statute calls for the prosecutor in order to prove. So they need to prove impairment beyond and to the exclusion of every reasonable doubt. The breathalyzer result is only one indicator, and just because somebody blows over the legal limit that doesn't necessarily mean that they are impaired, and it certainly doesn't mean that the prosecutors are actually going to be able to prove that they're impaired. I would agree with Mr. Brooks.
I don't have to get to the
in
point
the
where I
sense.
have to throw my
I'm sorry.
Listerine
Go
out,
ahead, sir.
do I? I don't have to get to the point where I got to worry about taking Listerine and throwing my Listerine out before I get in the car to go to work. Yeah, I mean, it's strictly it's impaired versus intoxicated.
Well, that's exactly right. Nobody is going to, appear to be impaired because they've taken Listerine. As Mr. Musca said, the breath test is something that is only one part of the equation, and something that's not administered until the officer has asked for the person to do the field sobriety exercises and has observed other forms or other characteristics of impairment. So, yeah, rinsing with Listerine is not in and of itself going to create an issue for you.
All right. I mean, I'm just using that as like an example. I'm not.
No, I understand. And Kevin, I want to make sure that I answer that. We don't go too far beyond your question. I want to make sure that I answer your question, because you do this topic of the breathalyzer actually, is an interesting one that brings up several issues that I'd like to get into as well. But before I do that, to go into that too far, I want to make sure that I've answered your questions, without extrapolating too far.
And you did, and I greatly appreciate your guys' time. I mean, there's so many different realms of it. And if you've had a drink, if you hadn't, you know what I mean? Do you feel like you're being harassed, even if you know you're sober and you're just in that state of mind where, why is this guy bothering me? I'm sober. Versus, I've had a few, do I do it, do I don't? You know what I mean? It's just, there's so many different realms of it that I just want to know if I could tell my friends, or maybe I'll be in that position.
Well, I mean, obviously, if you're in a position where, you're leaving a bar, a tavern, or whatever, or a restaurant, and you may be in doubt, obviously the safe thing to do would be to call a cab or call a friend, have somebody pick you up. Obviously, we're here for folks that, either might have committed a mistake, or maybe improperly or unjustly prosecuted. But at the same token, obviously, I always want to remind our listeners that when in doubt, call the cab, call the friend. Don't put yourself in a position to have to need us in the first place. Do the right thing. Call a cab. Call a friend.
Well, I tell you what, I thank you, gentlemen, for your time. Not to be rude, I hope I don't ever have to talk to you, but at least I know a little bit before I have to talk to you now. So thank you guys very much. I appreciate both your inputs, and may God bless.
All right. Thank you, Kevin. Thank you very much for the call.
Kevin, thanks for joining us.
Take care,
Thank you.
And in keeping with the topic of the breathalyzer, again, Mr. Musca alluded to the fact that it's only part of the equation. The state has to prove that the defendant or the suspect is guilty beyond and to the exclusion of every reasonable doubt before a jury or a judge can find that person guilty. And in order for that breath test result to even be admissible in court, in other words, in order for the state to be even able to use the breath test result, there's a number of safeguards that are in place to try to ensure its accuracy. Now, there's arguments out there, regardless, that the breath test instrument is not an accurate and reliable instrument, but I'll leave that for another day. But regardless of that, there are still additional safeguards that must be followed before that breath test result is even admissible. So let's say that you blew a .25, high number, whatever the case may be. You're looking at this and you're depressed and you're like, well, that's a high blow. I'm kind of in trouble. Well, we can't just assume that number is accurate or even admissible. There's a number of things that have to be followed in order for that number to come into court and be admissible. Was there a proper 20-minute observation followed by the breath test operator or the arresting officer? And I'll explain that. Before anyone gives a sample of their breath, if they agree to do so, they have to be observed like a hawk by either the arresting officer or the breath test operator. It could be either one, for 20 minutes continuously prior to submitting that first breath test. So I've had situations where my client was in the back of a patrol vehicle going towards the jail and en route to the jail where the breath test was going to be administered. And the arresting officer had started the 20-minute observation in his vehicle while he's driving. There's a mixed case law on that, but certainly the argument that I think is a very, very strong one is, how can the officer really pay attention to the suspect for 20 minutes while he's also driving and looking at the road and making turns and so on and so forth? So likewise, if, let's say, the officer is watching the person, and during that 20-minute observation, he goes to the bathroom or allows the person to go to the bathroom, and then doesn't restart after that for 20 minutes. That's a bad 20-minute observation. That means that breath test result can be suppressed by a judge. And it will not come in no matter what it is, no matter if it's a 0.09 or a 0.28. It's not coming in because the 20-minute observation was not properly followed. Furthermore, the person that conducts these breath test examinations or these breath test results, they have to be properly certified as a breath test operator. And by properly certified, I mean their certification has to be up to date. Not only that they were once certified, but that their certification is actually up to date and in order. If that's not the case, that's another reason why that breath test result can be suppressed. Also, the breath test instrument has to go through monthly agency inspections, as well as an annual. We have access to that. In order for a breath test result to be admissible in court, the state has to show that breath test instrument was properly tested and passed the month before, as well as the month after the breath test of that particular defendant. As well as the annual agency inspection report has to be in order. So these are just some of the things that can come up where a breath test result may be invalidated or may be suppressed by a court of law if any one of those factors is not up to par. So a competent and qualified attorney is going to know to look for that. And see if there are any of those issues that we can attack in order to have that breath test result suppressed. And again, Mr. Musca is a certified breath test operator, so he can attest to how important that is to not just assume that a breath test result is the end of the game, particularly a high one. That's only the start of things.
That's right. What machine was used? Has it been properly tested, serviced, maintained, and inspected according to guidelines? Has it been properly calibrated? Has it been always used by the people with the proper certification and training? An exhaustive intensive breathalyzer evaluation review needs to be done on each and every case. Otherwise, you're basically holding up the surrender flag to the state, which would be a big mistake because, again, the breathalyzer result in and of itself is only one indicator of impairment. Lacking others, there may be an opportunity to introduce probable cause, especially if we're successful discrediting the breath result in the sample that was produced.
That's exactly right. I know that we're coming up on 5 o'clock here, so before we wrap up our show for the day, I wanted to just quickly discuss one thing as well that I think is very important that we haven't discussed right now, and I'll do that very briefly. And that's the fact that once you are under arrest for a DUI, if you refuse to take the breath test or if you blow over a .08 or above, DMV is going to suspend your license. Now, you have 10 days to drive on your DUI citation if your license is otherwise valid, but DMV is going to suspend your license after those 10 days. So it's very important that you take immediate action so that a competent attorney can go ahead and challenge the suspension of your driver's license through a formal administrative hearing. That's a whole separate matter than the criminal case. We obviously handle that as well. We have actually an attorney that devotes her practice in our firm to just those formal administrative hearings. So very important to not wait, particularly more than 10 days, to get yourself a competent counsel. Because your driver's license suspension is on the line there as well. We can help you with that as well as any qualified, competent attorney.
You've been listening to Musca Law Radio. Musca Law is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Join us every Thursday at 4 p.m. right here on 1470 AM WNN, or log into muscalaw.com and watch the program stream live. Listen in next week, and thank you for joining us.